seated.
All right, good afternoon. Welcome to the final and championship round of the Spring 2026 Faegre Drinker Moot Court Competition. It's great to be here, and thank you all for coming, everybody in the room and also in our overflow room. It's wonderful to see the level of support that you all have for our final competitors. This is the culmination, right, of 3 weeks of competition among 64 teams. I did the math and I wrote it down, so that means we had over 130 rounds, and actually 162 rounds if you count the practice round, all culminating in today's final round. Our two teams here are to be congratulated. Representing the Petitioner, switch sides. Team 19, we have Vivek George and Meredith Martinez. Representing the Respondent, we have Team 12, Lillian Hawkins and Mackenzie Gillette. Let's congratulate our final two teams. Thank you, and I have some thank yous that I would like to make before the round starts. First off, to the sponsor firm, Faegre Drinker. They are the long-standing sponsor of the spring competition. They provide financial support as well as judging support, which we really appreciate. Here today we have our Chief Justice, David Kent, who is a Baylor lawyer and counsel at the firm. So we thank the firm for their support. We also thank the law school staff and faculty. Everybody in this building pretty much has a role in this competition, from podiums to judging to room assignments to IT to media. So we really appreciate the work that everyone in this building puts toward this competition. I also want to recognize the LARC 3 professors, and in particular Professor Barry, who has run the competition in the past and has also just been integral in making this spring competition happen as well. So thank you to the faculty and staff. Also very important though, this is a student competition, right? We have student competitors, student judges, and also students running the competition. In particular, I'd like to thank the Moot Court Board. So I'm gonna have you each stand when I recognize you. So first, I wanna recognize our barrister officers. We have Morgan Dawson and Kat McCurdy, so both of you can stand. They had the tremendous task of organizing and keeping in line over 180 barristers, which is quite the feat. We also have our two vice presidents who kind of do a little bit of everything, from checking in competitors and judges to filling in as last-minute bailiffs. We've got Zach Marshall, and we also have Ben Burdick-Rutz. They'll be back in the fall for more fun as well. And then finally, our two vice presidents, we have Shelby Trudeau and Lily Wilson, who made this competition happen. Thank you to the two of them. Also, I don't want to forget, when we're thanking students, I want to also thank our barrister judges who put in a lot of time and effort to making sure that this competition could be a success. And finally, thank you also to all of you who competed in the competition, right? Don't lose sight of the purpose of this competition. It's a learning experience. You're taking what you're learning in the classroom and putting it into play as what can feel like a real lawyer, right? In the courtroom. You take a difficult problem, you figure out the arguments for both sides, and then you make those arguments and have them tested in the rounds. Some of you may be disappointed that you aren't sitting up here. Some of you may be very relieved that you aren't sitting up here today. But again, just don't lose sight of the purpose, which is to give you an opportunity to step out of the classroom and into the courtroom to argue this case. All right, one last thing from me. is the judging panel. So I want to go through and introduce our judges. We have 7 judges on this final panel. First, we have our winners from the fall competition. We have Jake Hatcher and Sam Hagan. So thank you both for returning, and we'll have the winners of this competition come back and judge in the final round of the fall. We also have Jennifer Richards, who is a Baylor lawyer and founder of the Richards Law Firm. She's also an adjunct here at Baylor Law, so we really appreciate her being here today. We also have, as I said before, we have our Chief Justice, David Kent from Faegre Drinker, and then we have 3 professors on our final round panel today. We have Professor Jim Underwood, who knows a little bit of something about fraud, as a torts professor, right?
Okay.
What are you guys thinking? All right, and then we've got Professor Bates, who knows a little something about contracts, right? And then Professor Rachel Kincaid. She knows a lot about me in particular. Also, she knows a little something about arm's length transactions. It was not an arm's length transaction, me asking her to be a final round judge. I got a little, familial guilt and pressure. All right, so that's our final round panel. After this is over, the judges will retire to room 239 to deliberate. That'll take, 15, 20 minutes. So during that time, we'll have refreshments out in the hall for everybody to enjoy. All right, did I forget anything? All right, I will turn it over to you, Chief Justice, to call the case.
All right, thank you very much. And welcome everyone to this round. We call the case docket number 25 EEFF, Max Batesmeyer, the petitioner, versus Val Fusewood, DBA Fusewood Vintage Instruments Respondent. What says the petitioner? Are you ready to proceed? Yes, fine.
Yes, Your
And
Honor.
do you have any request about timing?
Yes, Your Honor. 2 minutes for rebuttal, please.
2 minutes for rebuttal. We have a timekeeper? Good. All right. And how are you going to split the time between you and your partner?
I'll be going 14 minutes. My co-counsel, Ms. Meredith Martinez, will be also speaking 14. So it'll be 1 minute from each argument.
Very good. Very good. And what says the respondent?
We're ready to proceed, Your Honor.
Okay, and how will you split your time?
15 minutes for issue 1 and then 15 minutes for my co-counsel on issue 2.
Very good. All right then, we're ready to hear from the petitioner.
Good afternoon, Chief Justice, Your Honors. May it please the court. My name is Vivek George, and my co-counsel, Ms. Meredith Martinez, and I are here to represent Mr. Max Batesmeyer on his fraudulent inducement claim against Mr. Val Fusewood. I will be discussing whether the disclaimer reliance clause in the agreement between the parties barred Mr. Batesmeyer's fraudulent inducement claim. Ms. Martinez will then inform you on whether the summary judgment evidence negates the reliance element of fraudulent inducement as a matter of law. Your Honors, in a matter of justice and integrity, your court has acknowledged and held a strong public policy that bars a promise from being enforced when it is created under the pretense of fraud or deceit. This here is a public policy that should bar a best friend from fraudulently inducing the other through the means of a weak and ineffective clause, which is the exact circumstances of the case we are in here today, where Mr. Fusewood is trying to create an intentional lie and has created an intentional lie and is trying to get out of it through the means of this disclaimer reliance clause. Therefore, allow me to explain why the appellate court erred in affirming the summary judgment against Mr. Batesmeyer for 2 main reasons. First, a disclaimer reliance clause standing alone is not effective in barring a fraudulent inducement claim. 2, opposing counsel is unable to meet the forestitorial factors your court has considered when evaluating whether a disclaimer reliance clause is effective as a matter of law. Your Honors, to that first point, your court in Forrestal v. McAllen has held and has contended that a mere disclaimer reliance clause standing alone will not forgive an intentional lie, even in their ruling in that specific case. Therefore, it is our contention today that, as in the previous cases, This disclaimer reliance clause alone should not be effective in barring the fraudulent inducement claim. In all previous cases, such as in Forrester v. McAllen, Islam Berger, Italian Cowboy, and even in Lufkin, the court has held that there has been other factors, also known as the Forrester factors, which have helped understand whether a disclaimer reliance clause can be effective as a matter of law. Particularly in this case, and comparing this case to other cases that your court has held, besides in Lufkin, this court has not applied a disclaimer reliance clause outside of a settlement agreement. And even in Lufkin, where your court has held it outside of a settlement agreement, Lufkin is very different and it's distinguishable because even then, your court understood and applied that it was only able to apply the disclaimer reliance clause because generally all 5 factors weighed in favor of the disclaimer reliance clause being enforced.
So is your argument that inside the settlement context, you don't need all 5 factors, but outside the settlement context, you have to have all 5 factors? Is that the difference?
No, Your Honor. My argument today is precisely that. When considering a disclaimer reliance clause outside of a settlement agreement, it is important to consider that all 5 factors must be met by the opposing counsel and by those who are trying to enforce a disclaimer reliance clause. In the settlement agreement, your court has created these factors and has applied these factors in various ways. But when considering them outside of that settlement agreement, it is important to note that they must all be met because in Lufkin specifically, the only case your court has considered a disclaimer reliance clause outside of a settlement agreement, your court enforced it because all 5 factors were met.
Did we specifically say that, or did we just happen to find that all 5 had been met?
No, Your Honor. Although you have not specifically stated that all 5 factors had to be met, your court held that that it was enforceable because all 5 factors were met, and that is what the precedent case has held. And today, we ask that you uphold that same precedent today when considering these factors, and that if opposing counsel is unable to meet all 5 of those factors, that a disclaimer reliance clause should not be enforced. It should not be able to bar a fraudulent inducement claim.
How are our lower courts applying Lufkin? Are they finding that all 5 factors must be met?
No, Your Honor. Although in some lower court decisions, all 5 factors haven't been met, the lower court and Supreme Court of Texas today hold very different reasoning, especially the fact that when considering in a policy standpoint, lower court understands it more in a precedent, while the Supreme Court of Texas, you have more of a reason to apply it for policy's sake. And today, if we are to apply disclaimer reliance clauses outside of a settlement agreement to such an extent where the factors are not met, then we will be applying and allowing for anybody to just stamp a disclaimer reliance clause on any agreement, and therefore allowing contract law to swallow tort law as a whole and not creating a distinction between the two, which is what these factors were meant to do in the first place. Furthermore, Your Honors, onto these 5 factors. These factors have been considered in the totality of the circumstances, but today we ask that you consider all 5 of them and that opposing counsel meet all 5 of them in order to enforce a disclaimer reliance clause in this particular situation.
So are you saying if we apply it as we did in our settlement agreement precedent, they have met the totality, but because you're asking us to find new in Lufkin, now we need to find all 5 are met today?
No, Your Honor. Even if we are to apply this as we have in precedent cases, in the totality of the circumstances, opposing counsel is unable to meet the factors that weigh in favor of not disclaiming this reliance, or the factors that weigh the heaviest in this particular case. And as you know, in the totality of the circumstances, the factors are weighed depending on a case-by-case
Do you
circumstance.
concede that any of the 5 factors are satisfied here?
Excuse me, Your Honor?
Do you concede that any of the 5 factors are met in this case?
Your Honor, we have conceded the 5th and final factor, which is if the language was clear, and that is the only factor that opposing counsel has been able to, as of right now, been able to thoroughly meet. The other 4 factors, Your Honor, is especially the 3rd factor, the arm's length transaction, as well as the 1st factor, the boilerplate language, as well as the discussions and negotiations that occurred, have not been met. And even if we are to apply this as precedent cases have in the totality of the circumstances, they will not be able to meet these factors. Therefore, Your Honor, allow me to point you to the 3rd factor and the strongest factor that weighs in favor of not enforcing the disclaimer reliance clause, which is the arm's length transaction, or the lack of, therefore, in this particular case. Your Honor, this is clearly not an arm's length transaction. And as found in Transcorp v. Petrobras, your court found and was graceful enough to provide us a definition for arm's length transaction, which is generally a transaction between two unrelated parties acting with equal bargaining power in each other's own interests. And specifically in Allen v. Devon Energy Holdings, your court found that to the definition of what an unrelated party is, that in Allen, not your court, Your Honors, but the appellate court in that case found that in Allen v. Devon Energy Holdings, that their relationship, which is very similar to Mr. Batesmeyer's and Mr. Fusewood's today, that their relationship was enough to contend that they did not meet the standard for an arm's length transaction, and that this was not an arm's length transaction because they were related parties. And
In what way were they related?
they were two best friends that had a similar relationship as Mr. Batesmeyer and Mr. Fusewood have today. And to that point, Your Honor, as shown on page 4 of the record, Mr. Batesmeyer and Mr. Fusewood were not unrelated parties and are not unrelated parties. They were best friends who grew up together and have known each other throughout their entire lives and even were a part in each other's weddings. Therefore, it would be erroneous to conclude that Mr. Batesmeyer and Mr. Fusewood's relationship did not extend prior to this transaction or any other transactions before this either. And therefore, if we are unable to meet this part of this definition that your court has provided us for what an arm's length transaction is, this cannot be an arm's length transaction.
Are you asking this court to find that there were fiduciaries?
Your Honor, although we do contend that Mr. Batesmeyer and Mr. Fusewood had some sort of informal fiduciary duty, but that is a discussion that that my co-counsel will be discussing further on in terms of the reliance and the justifiable reliance of the parties. But in this particular case, Mr. Batesmeyer and Mr. Fusewood's relationship does not meet what is considered.
Counselor, this is a $350,000 contract, right?
Yes, Your
I mean,
Honor.
a $350,000 contract, I wouldn't trust my mother to be on my side.
Your Honor, although you may feel that way, in many cases and in many circumstances, we trust our friends and our families, and especially when we are dealing with somebody of a close nature, it is important to consider that people regard things in different ways, especially in the case of money. And the fact that you and I can differ on this point should point further to the fact that this is not something that should be decided in summary judgment and should be further prolonged to be moved to a trial, and that it should be decided by a jury. Therefore, on to the next factor, Your Honor, whether or not this was a boilerplate language, or whether or not the language is boilerplate rather than negotiated, and if the discussions that arose around the specific representation were considered enough. To that, and this is split into two parts. The first part being whether it was boilerplate or not, and whether it was negotiated. And as defined in Black's Law's dictionary, boilerplate means ready-made or easy-to-use language that can be input into any document at ease. And Your Honor, Clause 2.1, as shown on page 15 of the record, is the definition of a boilerplate language because, for one, it has no specific language about any names of the party, no language about any representing counsel, and also does not have any specific representations about this case whatsoever.
Well, if we take your definition from Black's to its logical extreme, wouldn't that invalidate any pre-printed contract at all, a promissory note from a bank? Because it's got something that's filled out ahead of time for convenience, maker, borrower, lender, interest rate, and all of those are filled in, but you would say, well, that's not negotiated.
Your Honor,
That's a boilerplate.
Yes, Your Honor. The point of this entire factor, specifically this factor being split into two parts, is to understand whether or not the parties intended to disclaim the reliance. The boilerplateness of this language further points to the fact that Mr. Batesmeyer never intended to disclaim that reliance. Also considering the fact that they had signed this specific clause multiple times in prior transactions. This all points towards the fact that this is extremely boilerplate. And to the second part of that definition, Your Honor.
Or maybe it suggests that your client knew exactly what he was doing when he signed the contract, since he'd signed similar contracts multiple times.
Your Honor, I would contend that this difference between the languages points towards the fact, and your court has held that a boilerplate language is one of the factors, so we're just asking you to apply this to
I don't think we've ever confronted a case, though, this court on this issue where this is the third time that the plaintiff signed an identical disclaimer language with the same party and now acts like it's a surprise.
Although, Your Honor, this your question and answer, or your answer points towards whether or not the parties had discussed it. And the fact is, which is the second part of this factor, and the fact is Mr. Batesmeyer and Mr. Fusewood's discussions that arose are not considered enough to disclaim this reliance or about the specific representations, because as found in Transcorp v. Petrobras.
Would you give me an example of what would be appropriate language that evidenced that it was not boilerplate and that they did consider this?
Your Honor, if they had discussed the specific clause and discussed them and had a discussion about disclaiming the reliance, that would have been enough. And particularly as found in Transcorp v. Petrobras, Your Honor, in a case between two international entities in the petroleum industry, your court there held that the discussions that arose among those two parties was barely enough to tilt that needle in favor of enforcing that factor in whether or not the party was disclaiming the reliance. And therefore, if you were barely able to tilt that needle in Transcorp v. Petrobras, it should be easy to understand how in a drastically simpler agreement between two best friends on the sales transaction of a mere guitar with a two-page clause or a two-page contract, the discussions that arose among them for the matter of a few days should not be considered enough to disclaim that reliance.
Well, don't you think you're being a little cavalier to call it just the sale of a mere guitar? I mean, the whole point was it is a one-of-a-kind, irreplaceable guitar, the John Lennon guitar, the lost John Lennon guitar.
Yes, Your Honor. This was indeed, well, at least under Mr. Batesmeyer's understanding at the time, was supposed to be Mr. John Lennon's guitar. But this does not take away from the fact that in prior cases, your court has taken on this factor in understanding large settlement agreements and large transactional agreements between parties on an international and in million-dollar deals and investment in million-dollar transactions. And in comparison to that, which probably accounted to a multitude of transactional and corporate interests, this case on a sales transaction between the parties should not be considered enough. And therefore, for these reasons, I humbly ask that, may I please
Yes.
conclude? Thank you, Your Honor.
Finish your sentence.
For these reasons, I humbly ask that for the sake of justice, you reverse and remand this case to trial. Thank you.
Thank you. We'll hear from Ms. Martinez now.
Your Honors, Chief Justice, may it please the court. As Mr. George indicated, my name is Meredith Martinez, and today I represent the petitioner, Mr. Max Batesmeyer. This is a case about a man who trusted a lifelong friend and then had that trust betrayed. The lower courts granted summary judgment on the element of justifiable reliance, holding that Mr. Batesmeyer could not have trusted his lifelong friend. Today, we ask you to reverse that judgment and remand this case for trial. Because today's issue is a question of fact for a jury, and it is inappropriate for summary judgment. You should reverse for two reasons. First, this court has held that there is a high standard to negate justifiable reliance as a matter of law. And that standard is even higher in today's case because of the relationship between the parties. Second, the facts that opposing counsel alleges to be red flags fall short of that high standard. In Grant Thornton v. Prospect High Income Fund, this court held that reliance is justifiable unless it is extremely unlikely, given the plaintiff's characteristics, abilities, and appreciation of the facts and circumstances. It's extremely unlikely the plaintiff actually relied on the defendant's representations. Extremely unlikely is a high standard, and that's just the standard at trial. Today, we're here on summary judgment. Opposing counsel, Mr. Fusewood, must show that reasonable minds could not differ, that it is extremely unlikely that Mr. Batesmeyer actually relied on what his friend told him was true. And under Goodyear Tire, that's taking all facts and reasonable inferences in the light most favorable to Mr. Batesmeyer. So that standard's already high, and it's high in any case to negate justifiable reliance as a matter of law.
Counsel, let me just ask for a clarification. Is the standard that we're applying, I know beyond the summary judgment standard, but in terms of the reliance standard, is it completely a subjective inquiry, or is it an objective inquiry? Whether or not a reasonable person would have relied, is that even relevant?
Your Honor, whether a reasonable person would rely is not relevant for justifiable reliance. In Gin v. NCI building, a lower court held that reasonable reliance requires more out of a plaintiff than justifiable reliance. That's a lower standard. The question that the red flags that opposing counsel alleges must answer is not whether Mr. Batesmeyer should have trusted his friend, rather whether Mr. Batesmeyer did trust his friend and whether it was extremely unlikely that he did trust his friend. And in today's case, that standard is upped even more by the relationship between the parties.
So am I hearing it's a blend of subjective and objective?
Your Honor, we would say that it is a subjective standard that's measured objectively. In that relationship between the parties even further heightens that standard. In Thigpen v. Locke and again in Meyer v. Cathy, this court maintained that an informal fiduciary relationship, called a confidential relationship, can be created where because of a familial relationship or otherwise, one party is accustomed to being guided by the judgment or advice of the other. That is exactly the facts that we have today. You'll see on page 5 of the record, Mr. Batesmeyer and Mr. Fusewood have known each other their entire lives. They had sleepovers together in their childhood. They started a band in Mr. Fusewood's garage. They were in each other's weddings. And through their careers and even now into retirement, they've maintained a close relationship. That's over 50 years of trust. But not only that, you'll see on page 7 of the record, that trust extended into the world of vintage guitars. You'll see that Mr. Batesmeyer's only sold 2 guitars in his life. And in both of those transactions, Mr. Fusewood guided him at every step of the way, giving him advice, teaching him as a mentor. This meets that standard set that this court set in Thigpen, where one party is accustomed to being guided by the judgment of the other.
Does your argument stand or fall on whether or not we apply the informal fiduciary relationship label here? Because we've been very hesitant to do that. I forget the name of the case, but we had a case once where the evidence was that the parties shared a burrito every day for lunch for years, and we said that's not enough.
Certainly not, Your Honor. Our argument does not rise or fall. I believe the case you're speaking of is Meyer v. Cathy.
Yes.
And in that case, this court held that the reason we couldn't impose that fiduciary duty was not because they weren't close enough of friends, but because their friendship did not predate the transaction at hand. Today's case, the facts are very different. The friendship between Mr. Batesmeyer and Mr. Fusewood predated the transaction by some 4 decades. This is not the same case. And under that standard in Thigpen, we do believe that a fiduciary duty has been created.
What other cases do you have where a lawyer was one of the parties?
Well, in Allen v. Devancore, one of the parties was an attorney. However, traditionally, in considering red flags, this court has considered the sophistication of the parties, in particular to the industry. So while Mr. Batesmeyer is an attorney, and that would change the way that this court evaluates red flags, it does not.
But it's also a contractual relationship, and your client here specialized in those types of transactions, and so he may not have done a guitar before, but he was certainly familiar with the process of negotiating contracts and protecting the interests of the parties to a contract. So it's very difficult for me to believe that he could completely sort of take that hat off just because he was doing this on his own.
Yes, Your Honor, and this court does consider the sophistication of the parties when determining what constitutes a red flag. But that's not the only thing that this court considers, and certainly not only the general sophistication of the parties. To meet that high standard that you need to meet for a red flag to negate justifiable reliance, to meet that summary judgment standard, you need a little more.
Isn't that little more provided by the statement from your client that he was motivated by greed as much as hope in this transaction?
Your Honor, while Mr. Batesmeyer certainly wanted this guitar, the record also makes it clear on page 10 that Mr. Batesmeyer entered this transaction in reliance on his friend because he never thought that Mr. Fusewood would mislead him. And that reliance, whether it was reasonable or not, is what's at issue today.
Well, doesn't that negate, you just cited Thigpen, and don't we talk about in Thigpen that if it could have been discovered by a reasonably prudent person, then we can't only look at what the other side did, right? And So what's your argument against that?
As Thigpen addresses the fiduciary relationship, for the same reasons this court chose not to find that relationship in Meyer v. Cathy, the same was true for Thigpen. So the standard in Thigpen was not that fiduciary relationship, but even so, if the fiduciary relationship were to be found, under Thigpen, Mr. Bates-Meyer would be able to justifiably rely on Mr. Fusewood to treat him with the utmost fairness. But even if that standard is not met, the relationship between the parties under Orca Assets, this court has held that that relationship must be considered when determining what constitutes a red flag. And relying on the precedent of this court, the Dallas Court of Appeals defined red flags as circumstances that would warn a plaintiff of this plaintiff's experience and sophistication, that the representation being made, that he ought not place confidence in that representation.
Speaking of your client's sophistication, isn't your client quoted in the record as saying that he learned much from the first two transactions he did with the respondent?
Yes, Your Honor.
So he was already getting fairly sophisticated in guitar business, wasn't he?
We would disagree that he was sophisticated in the guitar business.
His client's own words.
Mr. Bates-Meyer believed that he was learning a lot from Mr. Fusewood as his mentor.
I think he used past tense. He had learned much.
He learned much. Certainly, Your Honor. As he was learning much under the tutelage of Mr. Fusewood. And that's important because in Roxo Energy, Barrow Shaver, Orca Assets, under the facts of those cases and the analysis that this court undertook in those cases, it was not just the general sophistication of the parties or even their sophistication within the industry, but the relative sophistication of the parties. Especially in Roxo Energy, this court considered the party sophistication in relation to one another. And in all of those cases, both parties had years, if not decades, of industry-specific experience.
So your client purchased a $1.5 million guitar for $350,000. Isn't that a red flag? Isn't that a deal too good to be true?
Your Honor, we do not believe that that is a deal too good to be true. And whether or not it's reasonable for him to trust his friend on that, on the representations about the guitar is not an issue today. But you'll see on page 8 of the record, Mr. Fusewood actually explained that discrepancy. He said he wanted Mr. Bates-Meyer to have the guitar as a friend, and made it very clear that their friendship was the basis for this transaction and the basis for the steep discount that he was giving.
So it was just $1 million gift from one friend to another?
Your Honor, even though he was getting a steep discount, Mr. Bates-Meyer was still aware that Mr. Fusewood was making over $340,000 on this transaction. It would not warn a person of Mr. Bates-Meyer's experience and sophistication, considering the relationship between the parties, that he ought not place confidence in his friend, who also happened to be an expert in this industry.
So am I hearing you say that he probably wasn't a reasonably prudent person, but because of the fiduciary duty overlay, that's excused?
No, Your Honor. Even if there was no fiduciary duty, the standard is not whether the parties acted reasonably. A party is held to exercise ordinary care, but this is not the same as to say that their reliance must be reasonable. This court has held again and again that justifiable reliance is the standard, and that standard is shown by showing that it's not extremely unlikely that there was actual reliance. So that is the relation that's at issue today, and none of the facts alleged in the record meet that high standard that this court has held.
So under Texas law right now, when does a purchaser have to investigate the truth behind representations, and when can they just rely?
Well, that's part of what red flag doctrine addresses. So red flag doctrines are warnings. A red flag is a warning that they ought to take that further investigation.
So without a red flag, you can absolutely rely on what the other party says?
No, Your Honor, certainly not. That is not supported by the precedent cases. But what is supported by the precedent cases is that when we're determining what constitutes a red flag, it is a consideration that's made in light of the sophistication, experience, and relationship of the parties. And in that light, the facts alleged by opposing counsel that are alleged to meet that high standard, they fall short. For instance, opposing counsel alleges that the mere unlikeliness of this guitar belonging to John Lennon ending up in Memphis, Tennessee, would warn a person of Mr. Bates-Meyer's experience and sophistication. But you'll see on page 4 of the record that this is exactly the kind of story that an inexperienced person like Mr. Batesmeyer would be most familiar with. It's the stories that make headlines, famous guitars that are lost and then found in unexpected places. And all things considered, Memphis is not so unexpected of a place to find a guitar.
But this particular discovery in Memphis did not become the subject of international headlines, like the Paul McCartney bass, Hofner bass, that was discovered and it was hugely covered. This wasn't. This was kind of like a secret that Val Fusewood was keeping to himself so he could lure in his friend, theoretically. Is that right?
Well, Mr. Batesmeyer had not, and Mr. Fusewood had not yet advertised that they had found the guitar. So we would not expect it, it would not be reasonable to expect it to make headlines quite yet. Furthermore, nothing about the unlikeliness of the guitar would suggest to Mr. Batesmeyer that his friend would be trying to defraud him or conduct some sort of deceitful enterprise. And in fact, none of the facts that opposing counsel has alleged today are going to go to the idea that would warn Mr. Batesmeyer that his friend was not to be trusted. In fact, as you'll see in page 8 of the record, Mr. Fusewood actually went to an independent authenticator who he presented to be a particularly skilled specialist at identifying guitars based on photographs and had a third party affirm that this guitar belonged to John Lennon. It is not, reasonable minds could differ whether it is extremely unlikely that Mr. Batesmeyer actually relied on what his friend said was true. It's not extremely unlikely. In fact, it's entirely natural that he would rely. For these reasons—
Why wasn't a certificate of authenticity issued by the expert? That's the usual practice in situations like this, but yet this person refused to do that. Shouldn't that have suggested a problem to your client?
Your Honor, I see I'm out of time. May I answer your question and briefly
Please
conclude?
do. Please.
Mr. Fusewood also explained this discrepancy, the fact that there was no certificate of authenticity, by saying that because of the unique provenance of the guitar, that this would be a particular case where they can't get that certificate. So he was relying on Mr. Fusewood's explanation of that as well. For these reasons, we ask this court to reverse the lower court's judgment and remand this case for trial. Thank you.
Thank you. Is the respondent ready to proceed?
Yes, sir.
Okay, we'll hear from you.
May I proceed? Chief Justice, Your Honors, and may it please the court. My name is Lily Hawkins, and I, alongside my co-counsel, Kinsey Gillette, represent the respondent in this case, Mr. Val Fusewood. There are two issues before this court on appeal today. I'll be discussing the first issue, that a disclaimer of reliance in the contract between Batesmeyer and Fusewood bars Mr. Batesmeyer's fraudulent inducement claim. My co-counsel will handle the second issue, that summary judgment evidence negates the justifiable reliance element of Mr. Batesmeyer's claim as a matter of law. Texas courts are courts of freedom and fairness. This is a case about maintaining those principles in a sales transaction between a longtime collector who is an experienced attorney and a vintage instrument seller. It is the exact type of transaction Texas courts have long protected, freely consented to by two equal parties, each capable of looking out for their own interests. This court should affirm the decision of the District Court and the 16th Court of Appeals for two main reasons. First, applying the factor test as set out by the Texas Supreme Court in prior cases would render this disclaimer of reliance enforceable. Second, Texas courts have long supported policies that protect parties' freedom to contract and resolve disputes while providing both sides of a transaction with legal certainty and equal protection.
What if we decide to adopt Mr. George's analysis and say that all 5 factors have to be met outside of the settlement context? Do you win then?
Your Honor, in this case, there is not a Texas Supreme Court precedent for applying it in that specific way. However, even in the event
Do you
the court—
agree that we applied all 5 factors and found that all 5 had been met in Lufkin?
all 5 were met in Lufkin, but the court never articulated that that was the reason why they ruled in favor. It just happened that all 5 factors were met.
What about an Italian cowboy? Didn't this court say that outside the settlement context, it would be tougher to persuade us to apply a disclaimer?
Your Honor, that is true that the court said that in Italian Cowboy. However, Italian Cowboy handled a disclaimer of reliance that was ruled to be simply a merger clause, so it did not even meet the clear and unequivocal standard that is conceded by both parties in Factor 5 of this case. So
You
that
brought
is,
up merger clauses. Didn't this court hold that a merger clause will never preclude a fraud claim?
that is correct, Your Honor.
So
However,
why do we allow a disclaimer of reliance to ever preclude a fraud claim? What's the difference between the two?
Your Honor, a disclaimer of
Shouldn't we
reliance.
revisit that whole issue?
No, sir, Your Honor. We do not think that should be revisited on appeal today. A disclaimer of reliance is meant to assess whether or not the parties explicitly chose not to rely on any misrepresentations. The key word is the word reliance, which this court held in Forest Oil, Lufkin, and Transcore. When the parties explicitly decide not to rely on any extra contractual misrepresentations, and it meets the Forest Oil factors, which judge the totality of the total circumstances, it is only fair for this disclaimer of reliance under this standard to be able to preclude a fraudulent inducement claim. And that is the issue before this court on appeal. Now, in Forest Oil versus McAllen, the court developed this 5-factor test. The 5th factor is a threshold question, whether the release language is clear, but it is conceded in this case. So we turn to the 4 extrinsic factors. To go back to your question, this court did in Transcore hold that when 3 factors point toward enforcing a disclaimer of reliance, but 1 does not, the disclaimer can still be enforced. That was in a settlement agreement, but it was not the exact same agreement as we saw in Schlumberger or in Forest Oil, and the courts of appeals in Houston, Dallas, and Fort Worth have all applied disclaimer of reliance clauses when not all 5 factors were necessarily met.
Which factor has not been met in this case?
In this case, Your Honor, all of the factors have been met, so even under the higher standard articulated by opposing counsel, this disclaimer of reliance would still be enforceable. It is important to remember that when we assess the 4 extrinsic factors and the totality of the circumstances, we are answering one key question. Did the parties freely and truly intend to disclaim reliance? This is meant to be a balancing test. It is not an element test where boxes must be checked. It is a complete analysis of contractual fairness in the context of this specific case.
Well, you talk about contractual fairness. Let's just assume for a second that the allegations are true. You're telling us that we should expect the general public, lawyers, businesses, everyone to say, well, yeah, you can get away with complete fraud. You can pocket $340,000 net profit by deceiving your friends as long as you have this type of disclaimer written into the document. Isn't this the type of case, if you accept the truth of the allegations, where we have to give precedent to fraud vitiates everything?
Your Honor, in this case, I'd like to respond on 2 different points. First, we are at the summary judgment standard, and so we are not asking whether or not this was actually a fraudulent misrepresentation. However, even if that is true, to answer your hypothetical, in this case, Texas also has a strong policy that protects parties' freedom to contract when 2 sides are sophisticated and capable of intending to disclaim reliance.
So we're going to say, well, yeah, you got duped, tough luck. We're going to let this guy intentionally defraud you. That's okay.
No, Your
That's
Honor.
what you're saying?
No, Your Honor, that is not what we are advocating. However, we are advocating that just as Texas has a strong policy against fraud, Texas also has a strong policy protecting the freedom to contract. But those 2 things do not have to work in opposition to one another. A fraudulent inducement claim is a cause of action that protects a party when one side had their fingers crossed behind their back. But as this court noted in Forest Oil, it is also easy for one party to lodge an after-the-fact representation they were fraudulently induced into a contract when a transaction simply does not go their way. Applying this exception that does allow a disclaimer of reliance when it meets the Forest Oil factors to preclude a fraudulent inducement claim protects the other side of the transaction. And Texas courts have held cause of action that protect both sides. We are not advocating that fraud does not matter in this case, but it is important in this case to hold a precedent that protects both sides of a transaction, not just one, which will, as the court moves forward, will be able to apply to any case that comes before this court.
You know what, I'm glad you keep mentioning Forest Oil, because it's such a great example of, I think, when a disclaimer should be applied, should be enforced, rather. I mean, yes, we love freedom of contract. We hate fraud. So what do we do with the disclaimer? Well, in Forest Oil, we said, well, in the settlement context, there's an additional policy, which is the finality of settlements. And that was true in Forest Oil, it was true in Schlumberger, it was true in Transcore, right? And I don't think I'm aware of a single case from this court where the argument has been made to limit disclaimers to settlements where we've enforced it. We've enforced it outside that, but not where the argument was made to limit its applicability. Wouldn't that clarify Texas law if we did that today?
Your Honor, in this case, we would advocate the forest oil factors are already a clear legal standard that can be applied to contracts. This court has never held they're only applied to settlement agreements, and even in the Court of Appeals, they have been applied only in certain circumstances. Here, the factors provide a narrow enough analysis, so I'd like to move to address the factor opposing counsel points out about whether or not these parties were dealing at arm's length. This court has generally defined an arm's length transaction as a transaction between two unrelated parties with generally equal bargaining power, each acting to protect its own interest. And while opposing counsel argues for some type of informal fiduciary duty, we would like to point the court to its holding last July in Pitts versus Rivas, where this court held the law will not lightly impose even informal fiduciary duties on parties in a business relationship. And the facts of this case are analogous to the facts in Pitts. For example, Mr. Rivas relied on Mr. Pitts to complete services for him. He offered him unpaid advice. Mr. Pitts, at certain points, provided a discount on his building services for Mr. Rivas. The two men were friends, had dinner with their wives, and their sons were even college roommates. Yet this court held on summary judgment, when viewing all the facts in the light most favorable to Mr. Rivas, they could not impose informal fiduciary duties to elevate the standard of conduct outside of an arm's length transaction. And that is our case. As the record notes on page 10, Mr. Fusewood did twice give Mr. Batesmeyer some unpaid advice. He did discount the price of the guitar, although with a contingency that he would receive a percentage of the later profit. And the two men had kept up a childhood friendship. But those facts are similar to Pitts. And in Pitts, when this court held there was not enough information to elevate it outside of the arm's length standard of a business transaction.
But in effect, this was a partnership, wasn't it? This transaction, they were going to split any sort of additional profit, and so this was a partnership. And don't partners have certain fiduciary obligations to one another?
Your Honor, I would respectfully disagree that this was a partnership. There is no evidence in the record that these parties ever had any type of business partnership. Mr. Fusewood making a good business deal, getting a percentage of the profit now in order to keep being able to do his business, which is buying and selling vintage guitars, but holding a contingency, does not make these parties fiduciaries. And in this case, these two parties were parties with equal bargaining power that were in fact acting for their own interest. It is important to note that Mr. Fusewood was a vintage instrument seller. This was his business. But Mr. Batesmeyer was an experienced business attorney who likely had more experience in transactions and litigation than Mr. Fusewood even had.
Let's touch on that, because you said earlier that all 5 factors have been met, but it says represented by counsel.
That is correct, Your Honor. That is the second factor.
Right, and he was not represented by counsel, if we're just looking at the black letter of the law. So what is your standard for when an attorney who is not represented by counsel suddenly is represented by counsel just by being an attorney?
Your Honor, in this case, because the forest oil factors are not an element test, it is not necessarily a black and white yes or no. We do advocate for the fact that not every attorney automatically meets this factor simply by being an attorney. That would not be a fair standard, and it is not the per se rule we argue for. But in this specific case, taking into account Mr. Batesmeyer's specific knowledge, as noted on page 5 of the record, in transactions, drafting contracts, and then spending 22 years working in business litigation, he was capable of intending to disclaim reliance. Most parties, your average consumer, seller, will not understand the terms of a contract. They do not have the legal training and expertise that makes that possible.
So, counsel, is it your assertion that even if this had been his first time purchasing a vintage guitar, he already at that point was a sophisticated party because of his extensive business background, or are his previous purchases relevant?
Your Honor, we advocate his previous purchases are relevant. They are more relevant to the consideration of the fourth factor, which is about Mr. Batesmeyer's general business knowledge. And to finish this factor about the represented by counsel, because he had the capacity to understand the disclaimer of reliance and consent to the terms, he meets the policy consideration that underlies the forest oil factor test. It is a balancing test that he satisfies.
Is that balancing test a fact issue? Is that appropriate for summary judgment?
Your Honor, this court held in Italian Cowboy that applying the forest oil factor test to a disclaimer of reliance is done as a matter of law in summary judgment. So the fact that there are fact questions within the factors is appropriate still for this court to hear on summary judgment. To go back to Your Honor's question about the party's sophistication and knowledge, the fourth factor asks about Mr. Batesmeyer's knowledge of the business. This court in Lufkin held that general business knowledge is enough to satisfy this factor. There does not need to be some kind of requisite sophistication or specific experience to satisfy it.
Counselor, did you read all 25 pages of your cell phone service contract before you signed it?
No, Your Honor, I did not.
So that's because we're lawyers, but when we're acting on our own behalf, we're not wearing the lawyer hat, right? So isn't it unfair to suggest that just because he happened to be a member of the bar, 24 hours a day, 7 days a week, 365 days a year, that's the way he approached everything he did?
Your Honor, I would advocate that because this was only a 2-page contract and he was participating in what may have been a $1.5 million transaction, to not have read 2 pages and seen a disclaimer of reliance clause is something that as attorneys who are trained to be skeptical and do their research on every term, even prior to signing something, he was held to a standard that he at least should have read through and understood a 2-page contract he was handed that he had over a week to negotiate and discuss. Back to general business knowledge, Mr. Batesmeyer there are 2 key considerations as to his knowledge as a business person. The first is the fact that he was an experienced business attorney, but he also did have knowledge in this particular industry. The record notes on page 9, and as we should take Mr. Batesmeyer's own words into consideration, he told Mr. Fusewood in 2019 he was learning so much that he thought he could do this as a side business. When an experienced business litigator says he had the knowledge and had the knowledge in 2019 to do this as a side business, we must take him at his word that he at least satisfies the general business knowledge standard articulated by this court in Lufkin. Your Honors, these parties dealt at arm's length. Mr. Batesmeyer does meet the represented by counsel factor because of his sophistication and experience. He has general business knowledge, and this contract was not boilerplate, as was suggested by opposing counsel. This contract was negotiated for over a week, multiple terms and opportunities for Mr. Batesmeyer to point out the disclaimer of reliance and ask about it. May I briefly conclude?
Yes, please.
For these reasons, we ask the court to affirm the decision of the District Court and the 16th Court of Appeals and hold that this disclaimer of reliance is enforceable. Thank you.
Thank you very much. We'll now hear from Ms. Gillette.
May I proceed? Chief Justice, Your Honors, and may it please the court. My name is Kinsey Gillette, co-counsel for the respondent, Mr. Val Fusewood. I will be continuing arguments on behalf of Mr. Fusewood today regarding the second issue, that the summary judgment evidence negates the justifiable reliance element of Batesmeyer's fraudulent inducement claim as a matter of law. Simply put, this case is about fairness and holding a sophisticated party accountable due to the multiple warning signs present in a transaction. Today, we are asking that this court affirm and find for Fusewood for 2 main reasons. First, Batesmeyer's level of experience and sophistication established as a matter of law that he could not have justifiably relied on Fusewood's alleged misrepresentations surrounding the guitar. Second, Batesmeyer had a duty to protect his own interest because of the red flags present in this case. Thus, his reliance cannot be classified as justified. Now to my first point, that Batesmeyer's level of experience and sophistication established as a matter of law that he could not have justifiably relied on Fusewood's alleged misrepresentations. This court in Orca Assets used the term red flags to mean circumstances surrounding an oral representation that would warn a person of the plaintiff's experience and sophistication that he should not place confidence in those representations. Based off of this definition, we must consider the facts of this case from the position of Batesmeyer, a sophisticated attorney with a lifelong interest in vintage guitars. This concept of holding parties to their level of experience and sophistication is rooted in fundamental fairness and the integrity of the legal system.
How can it be fair to say, well, that's fine, you just got swindled, intentionally swindled, but gee, you should have been smart enough to catch it? How can that be fair?
Your Honor, we believe that it is fair, first for two reasons. Firstly, at this time at issue, we're not discussing whether or not the claims made by Fusewood were genuinely fraudulent or not. Second, this court has identified a narrow circumstance where the justifiable reliance can be negated as a matter of law, that being when there are red flags to warn a person of the plaintiff's experience and sophistication.
Well, I know you say it's happening at the summary judgment point, but still, if we rule in your favor, if we affirm the Court of Appeals, then that's done it. It is a final decision without ever getting it in front of a jury to let a jury evaluate the fairness of it all.
Yes, Your Honor, and we believe that that is the decision that should be made by this court today. As my opposing counsel did note out, it is a high standard to say that it is extremely unlikely for Batesmeyer to justifiably have relied. However, we believe that that is the standard here, and it would be inefficient to resolve this solely as a matter of, or as a question of fact, because of the sufficient red flags here, and because of considering the fact that Batesmeyer has extensive legal training and a lifelong knowledge in guitars. Now, if this court were not to expect more from parties with superior knowledge, we would effectively be running the risk of allowing sophisticated members of society to take advantage of the legal system when transactions don't go their way. Therefore, this case must begin with a clear-eyed assessment of who Batesmeyer is and what he knew. Batesmeyer has had a lifelong interest in guitars. He specifically acquired an interest in vintage guitars in the 1990s. He sustained this interest by attending the Dallas Guitar Convention and subscribing to magazines on the subject matter. Critically, Batesmeyer is also an attorney. He began his career in the transactional sector at his law firm. He aided clients through sales transactions and drafted contracts himself.
What do you say to Ms. Martinez's position that even if it would have been justifiable, given the fiduciary relationship between the parties, or even just setting aside fiduciary duty, just the longstanding trust and relationship, that what would normally be reasonable, just that standard is almost lowered based on the relationship of the parties?
Yes, Your Honor, that gets to my second point, that regardless, Batesmeyer bore a duty to use reasonable diligence in protecting his own interests. The petitioner did argue that that standard of care was lowered because of the friendship here, but as this court made clear in Barrow-Shaver, the duty of using reasonable diligence is not excused by the mere trust and the familiarity of the opposing party.
Maybe not excused, but adjusted?
No, Your Honor, we believe that that is not the case here because the duty of using reasonable diligence acts independently of any relationship between the parties. We believe that trust or familiarity with a counterparty cannot serve as a substitute for due diligence, and this court should not permit it to serve as one.
What if they had been brothers? Does that change it?
Your Honor, if they had been brothers and there was a direct blood relationship, that may change our perspective and even qualify it potentially as a formal fiduciary duty. But here the parties merely had a prior relationship and it was not one of blood relationship.
What about stepbrothers?
Your Honor, that may be a different case, but however here, that is not the relationship between these two parties. And as my co-counsel has already stated, we do not believe that the years of relationship here remove it from an arm's length transaction. Which, to continue my duty argument, with an arm's length transaction, a plaintiff is not only required to use reasonable diligence, but is further charged with knowledge that would have been easily discovered by a reasonably prudent person so situated. Therefore, in this case, Batesmeyer's experience and sophistication becomes all the more consequential. As this court made clear in Barrow-Shaver, a plaintiff in an arm's length transaction cannot merely rely on the statements by the defendant when the plaintiff's experience, knowledge, and sophistication alert it to investigate before acting on reliance. Here, Batesmeyer's knowledge and experience with both professional legal training and his interest in guitars gave him the tools necessary to evaluate the deal before proceeding. Had Batesmeyer undertaken even a minimal amount of investigation, he would have discovered the easily known fact that this guitar was not John Lennon's. Therefore, under a duty of care applicable...
What would have revealed that to him?
Your Honor, there were many discrepancies with the guitar at issue here. One of those was the serial numbers had been forged, and there were marks that showed that they might not have been authentic.
Forged by your client?
No, Your Honor. The guitar that our client received had those discrepancies already there. Additionally, there was a sticker that had been later revealed to have been put there only 3 years prior, and not when this had supposedly actually been owned by John Lennon in the 1960s.
How would he have known that? That fact was only revealed by a subsequent detailed investigation. How would any purchaser know that?
Your Honor, while it might be true that Batesmeyer himself could not have found out this information, he had the tools necessary to seek out a third-party appraiser or demand a certificate of authenticity, as you noted, was present in the prior transactions. Here, the parties contemplated the transaction for an entire week when they could not have agreed upon an initial price. During that week-long period, Batesmeyer had the opportunity to take it to another third-party appraiser, yet he failed to do so. Now, moving back to the red flags.
Counsel, before you do that,
Yes.
why is this duty to inquire only on the petitioner, whereas your client also had equal opportunity to ensure that this product he was selling to his friend was what he actually stated? So why is it only on the petitioner to ensure that this is actually a proper product?
Yes, Your Honor. Whenever a plaintiff brings a fraudulent inducement claim, they are the ones asserting that the defendant had lied to them and induced them into a fraudulent contract. Therefore, that duty is on the burden of them to use reasonable diligence. And here, Batesmeyer, a trained transactional attorney, knew the risk in relying on the seller in an agreement. Now, moving backwards to the sophistication and the experience of the parties, we do acknowledge that the parties differ in their respective degrees of knowledge surrounding the vintage guitar market. However, any such disparity is immaterial, as Batesmeyer was undoubtedly in a position to understand the weight of the deal that he was entering into. And
I think I
Roxo,
need to go back to my co-justice's question, because that's an important one. What if your client did know it was fake? If, as your co-counsel said, his fingers were crossed behind his back, where at this summary judgment phase do we get to assess that? Because I'm also worried about Chief Justice Kent saying this is the summary judgment phase. We may never get to your client's bad acts.
Your Honor, at the summary judgment level and with a fraudulent inducement claim, we're asking what the client knew at the time of signing the agreement and at the contract. And here, Batesmeyer was not under the impression that this guitar had not been owned by John Lennon. However, as I've already noted, there's a narrow exception when this justifiable reliance element can still be negated as a matter of law. And here, Batesmeyer has superior knowledge.
But shouldn't he have been suspicious because the expert would not give him the certificate of authenticity that he normally would have given? He withheld it specifically because of the unknowns in this case?
Your Honor, we agree and believe that this is a sufficient red flag. Fusewood had two reputable experts that he continuously worked with, yet in this transaction that supposedly was such a strong one in relating to an important instrument, he chose to use a different expert, and it begs the question of why. And Batesmeyer did not inquire behind why. He did not ask why there was a difference in that transaction, and therefore that could have or should have alerted him to investigate further before acting in reliance on the professional who it was his first time working with Fusewood here.
Well, I keep getting troubled by this whole idea that these were so obvious, such obvious red flags that any fool could plainly see it was a fraudulent transaction. Doesn't that really play into the plaintiff's point that he did get fooled by this because of the relationship, specifically and precisely because of the relationship? So looking at the totality of the circumstances, doesn't that guarantee that he gets a trial on that point?
No, Your Honor, we do not believe that is the case. As I've mentioned priorly, the duty to use reasonable diligence acts independently of any relationship between the parties. Therefore, regardless of the years of relationship between Batesmeyer and Fusewood here, Batesmeyer still bore a duty to use reasonable diligence in protecting his own affairs.
Well, now you're talking about it as if it is a checklist. Your partner said that it's not a checklist. It's a totality of the circumstances.
Your Honor, in my co-counsel's case, it is a totality of the circumstances for the disclaimer of reliance. However, here, when we're analyzing the red flags, they're viewed as a whole and not in isolation, and the duty is either checked or it's not. Those two elements and the issues on appeal here are different in that way. Now, going back to the disparity in the knowledge between the two parties.
Counsel, let me interrupt you there. It's one thing, I think, when the red flag is in the contract itself, like where the plaintiff says there's been an oral representation, but the contract says otherwise, like in the BMW or Mercedes-Benz case, whichever one it was, one of those German cases. But here, there's nothing in the contract that's inconsistent with the alleged oral representation. Under these circumstances, shouldn't it always these red flag cases like this one go to the jury?
No, Your Honor,
Is there a case close to this one where summary judgment's been affirmed on a red flag basis?
Yes, Your Honor. That was in Grant Thornton, which was decided by this court.
What was the red flag there?
Your Honor, that was that the funds that they were relying upon, the fund reports that the party there was relying upon, they had knowledge that the largest financial contributor to that company had recently been removed, and therefore they were on shaky ground, and that was enough to have alerted it that it could not have acted in reliance on that justification. Now, Your Honor, you made a good point about the fact that there is not a direct contradiction in this contract. However, there is absent any language confirming the oral representation in which the plaintiff bases his fraudulent claim upon. In Roxo Energy, this court held that the justifiable reliance element can be negated as a matter of law when there is absence any language in the final agreement confirming the oral representation.
That sounds like you're relying on the merger clause to preclude the fraud claim.
No, Your Honor, we do not believe that that is the case. What we're simply asking here is whether or not someone in the position of Batesmeyer should have expected to see the oral representation that they relied upon in the final agreement. Here, Batesmeyer is a trained transactional attorney, and he knew the importance of written terms.
So a trained transactional attorney to sue for fraud, they can no longer sue for fraud based upon an alleged oral misrepresentation.
Your Honor, if that alleged oral representation is conspicuously absent from a final agreement, that would alert a trained...
When would that be?
Your Honor, that was because a trained transactional attorney such as Batesmeyer, he knows the risks inherent in relying on those oral representations that are conspicuously absent. He knew that if those oral representations were not present in a final agreement, that indicates that those oral representations were not
But that's not actually true. This is an Article 2 transaction, and part of the contract in a sales of good transaction like this includes the conversations the parties are having in the process of negotiating the contract. The parole evidence rule is a very low threshold, and so we consider the contract to include those conversations. So technically, under Article 2, they were part of the contract.
Your Honor, the parole evidence rule relates to what terms are in the contract and what are not. I see that I'm out of time. May I briefly answer a question?
Please finish.
Under the parole evidence rule, the UCC asks with the intended scope what almost would certainly be included in the intended scope and in the agreement. Here, if the whole oral representation in the material dispute as to whether or not this was John Lennon's guitar, that almost certainly should have been included. Therefore, for these reasons, we're asking that this court affirm. Thank you.
Thank you. Please.
May it please the court. This court has set high standards. You set high standards to enforce a disclaimer of reliance, and you set high standards to negate justifiable reliance as a matter of law. And this case does not meet the standards that this court has set. Opposing counsel said that Texas courts are courts of freedom and fairness, and we agree. And that's exactly why this court has such a strong policy in preventing fraud. Free and fair contracting requires the ability to enter into a contract without fear that you're being deceived. This court recognized that policy in Italian Cowboy, in Schlumberger, and in Forest Oil, where this court said that this holding should not be construed to say that mere disclaimers standing alone will forgive intentional lies. Fraud vitiates everything it touches. To allow a factor test made for settlement agreements to apply the same way where the policy supporting settlement does not apply would set back this state's interest in preventing fraud. We do take off our attorney hats, especially with those that are closest to us. Fiduciary or not, this court has recognized that when considering red flags, part of that consideration must be the nature of the relationship between the parties, because that impacts what reasonable diligence looks like. That impacts what would be justifiable in a given scenario. What is extremely unlikely that one person would rely on the words of another. Friendship changes that standard. And that's why this is a question for the jury. Whether it's extremely unlikely that Mr. Batesmeyer would rely on his closest friend, who's an expert in an industry and has been corroborated by another expert, that's a question of fact. It's not appropriate for summary judgment in today's case. For these reasons, we ask this court to remand this case for trial, because this is a case where a jury needs to see it. Thank you.
Thank you. All right. Thank you very much. Excellent round. Now comes the fun part. We're going to be excused and you all sweat it out.
Good evening, everybody. I am not the one who's going to announce the winner, but I want to say to ladies, fantastic job. Mr. George, I wasn't here for your part, but I assume it was brilliant. That was a really good round. You represented yourselves well and the law school, and I thank you for it. I also want to thank the Fager Drinker firm and David Kent for coming out. We can't do these sorts of things without support of your firm, and so this is a great educational experience for all the students here and even more, and we're deeply, deeply grateful. Let's give the firm and David Kent. I also want to thank Jessica Kincaid and Mike Berry, who take the lead on running this tournament this time around. And I'm going to ask Mike Berry to come here, please. Mike,
Yeah.
come here.
Yeah.
Yes, yeah, Mike, sorry, buddy.
Yeah.
So Mike is passing the baton to Professor Kincaid after years of running this tournament twice a year, providing an exceptional experience for our students. I'm so grateful to you, Mike, and there's a generation of Baylor lawyers out there who are better for what you've done. So again, yeah, absolutely. I want to thank all of our judges, Professor Jim Underwood, Professor Larry Bates, Jennifer Richards, my friend, David Kent again, Professor Rachel Kincaid, and our student judges. Sorry, guys, I can't immediately remember your names. Jay Catcher, Sam Hagan. Very grateful to you all. And so I don't want to delay with long remarks because I know you all are ready to know the winner. But I got to tell you, being here brings me back almost 30 years ago when I competed in the spring moot court competition, and I made it to the final round, and I lost. So if you win, you will sit where Sam and Jake are, and if you lose, you will return to be the Dean of Baylor Law School. You all did a great job. You should be proud of yourselves, but, this is Baylor, so there has to be a winner.
Okay, well, thank you very much, Dean. And I will echo his comments. More than 30 years ago, I sat in the tables you guys were at. I will not reveal what happened, but I know how you feel about it, and I know the tension that goes with it. And I would also like to say, speaking on behalf of the firm and my now retired partner, Neil Rambin, who was instrumental in getting the sponsorship for this, that we have had a long and distinguished group of Baylor lawyers who have been part of our law firm, and yet it's never enough. So keep us in mind in the fall when it's time for recruiting. Okay, this was a fantastic round. Every one of us agreed that it's a good problem, and it was improved by the quality of the presentations by both teams. It was a difficult choice to make. It was one that we did make, however, and so the winner of this year's moot court competition is the Respondent team. And that's it from our court is recessed. There are refreshments outside. I don't know if Jeremy, you have anything else? Oh no. Yes.
We've got some more awards, so
Oh, okay.
I'm going to turn it over to the moot court officers to hand out a few more awards.
Thank you all for coming. I just want to echo that everything that Dean Counselor had said. This would not be possible without Professor Berry and Professor Kincaid. As Kincaid said at the start of this, there was 162 rounds, hundreds of ballots, and could not have done it all without Professor Kincaid double checking everything and being there every day, every minute, scrutinizing over every ballot and making sure it was a fair and fun competition for everyone. So I just like one more round of applause for Professor Kincaid. I'd also like to thank the exec team. It does take a village. It was an incredibly large class that competed this year and could not have done it without every single member of our exec team. So thank you guys. So now for the fun part, we have some awards. We're going to go through, there'll be a few different times where we'll have people come down and collect awards. We'll start with the semifinalists. So when we call your names, if y'all could come down and receive your plaques. I do want to make just an announcement before we start handing out awards. Everyone who receives an award or recognition today, if you guys could stick around for some photos afterwards, that would be great. So semifinalists, Team 7, Allie Kendrowski and Pemberley Farmer, if y'all could come down.
And Team 18, Tessa Lassett and Alana Rusco.
Congratulations. The runners-up from today, Vivek George and Meredith Martinez. And this year's champions, Lillian Hawkins and Mackenzie Gillette. So like I said, it was a very enormous class. We had quite a few ties for the top 10 of Best Speaker Awards. So we're going to be recognizing 9 of the students who placed 4th through 10th in alphabetical order. If you're called, can you please stand to be recognized? Jason Bryant.
Michael Friedenberg. Peter Geigel.
Olivia Grafmank.
Andy Mayfield.
Kaylee Moe.
Anu Pillai.
Dominic Vicino.
And Coy Wilson.
For the top 3 speakers, if y'all would come down and collect your plaques. In 3rd place, Adam Densmore.
In 2nd place, Alexis Weeb.
And the best speaker, Ashlyn Dodson. congrats to everyone who participated and survived this round of moot court competition. You should all be very proud. Again, if you received recognition or an award today, please stick around so we can get some photographs with y'all. Congrats. Thank you all.